Good afternoon, everyone. I'm delighted to kick off this year's blank lecture on attorney ethics, and I'm going to turn the floor over to Dean Anderson to introduce the lecture. But just wanted to note quickly first that we'll start taking questions in the chat that our speaker will hopefully be able to get to at the end of her lecture. So any questions that occur to you, please type them into the chat whenever you would like. Thank you.
Thanks, Professor Pollins. Hello, everyone. I am Horace Anderson, Dean of the Elisabeth Haub School of Law at Pace University, and I want to welcome you to the 2022 Philip B. Blank Memorial Lecture on Attorney Ethics. The Philip B. Blank Memorial Lecture was established by the family, friends, and colleagues of the late Philip B. Blank, Associate Dean for External Affairs and Professor of Law at Pace University School of Law. For more than 30 years, the Blank Lecture has been presented to distinguished members of the legal community who are recognized for their leadership in the area of attorney ethics and practice in honor of Dean Blank's commitment to legal ethics. We are thrilled today to have as our speaker, Irene Joe, Professor of Law at UC Davis School of Law, who will speak on the topic of learning from mistakes, ethical considerations for public defenders. Now I'd like to turn the program over to Professor Dorfman, who supervises our Barbara Salkin Criminal Justice Clinic and trains our students in all aspects of representation for indigent defendants charged with misdemeanor crimes in Bronx County. The lessons of today's lecture should be particularly salient for our clinic students, and I want to thank Professor Joe for presenting here today, and now hand the podium over to Professor Dorfman.
Thank you, Dean Anderson. So it is my honor and pleasure to introduce Professor Irene Joe, who will deliver the 2022 Philip Blank Lecture on attorney ethics. Her topic, the ethical dilemmas and challenges of public defenders, particularly in avoiding wrongful convictions, is a subject that for me, as a former public defender myself, and as a clinician in Bronx County, as Dean Anderson indicated, representing indigent folks charged with crimes, couldn't be more important, couldn't be more timely. And of course, Professor Joe comes to the topic with the highest credentials, bona fides, and the great passion that you will hear as she speaks in a few moments. Prior to her joining the University of California Davis Law School faculty in 2016, Professor Joe worked as a fellowship attorney for the Equal Justice Initiative of Alabama, representing Alabama death row inmates, as well as children in Arkansas and Florida sentenced to life in prison without the chance of parole. She then served a year as a federal clerk for Judge Napoleon Jones Jr. of the Federal District Court in the Southern District of California. After that, she served as special litigation counsel in the Orleans Parish Public Defender's Office in New Orleans in the almost direct aftermath of Hurricane Katrina, and helped organize that office, which had been so devastated by that horrific storm. She then became assistant training director of the Louisiana Public Defender Board, training indigent defenders statewide in the state of Louisiana. After that 3-year stint, she joined UCLA Law School as a Binder teaching fellow and visiting professor, teaching and supervising a voir dire clinic, as well as most tellingly teaching a course in the ethics of criminal justice, which is her specialty. During this last 6 years on the UC Davis faculty, where she is a professor, she has been teaching criminal law, criminal procedure, and professional responsibility, as well as special seminars and topics. She has published 10 superb articles keying on topics like the work and challenges of public defense, implicit bias in the federal courts, and the ethical requirements of prosecutors in this era of mass incarceration. So there's so much more to say about Professor Joe's illustrious career and important contributions, but every minute I spend lauding her delays your pleasure in hearing her speak on such an important subject. So without further ado, I give you Professor Irene Joe.
Thank you so much for that kind introduction. And good afternoon to everybody. Thank you all for being here today. And thank you also to the organizers for inviting me to present the 2022 Philip Blank Memorial Lecture on Attorney Ethics. Dean Blank's work clearly conveyed a commitment to the advancement and better understanding of the legal profession and the rules that guide it. And it's truly an honor to present today as part of that legacy. Who the public defender is, what the public defender does, and how the public defender does its job within our system of legal ethics and professionalism are important questions that have been the primary motivation in my scholarship so far. Even before this current moment of national preoccupation with criminal justice reform, there's always been some concern about the criminal process and how to make it more equitable, how to make it more just, how to make it more fair. Indeed, that was part of the reason why the public defender was even created in the first place. So it's surprising to me that most of the solutions to criminal justice problems have focused on changing what other actors do, actors besides the public defender. People have looked to the legislature for decriminalization. They've looked to police officers and problems with their use of force. There have been discussions and studies about racial bias in prosecutorial charging decisions. And there have been questions about what the lack of diversity on the bench or on juries means for the integrity of our criminal process. And each of those inquiries is important. But if that's all that we are concerned with when we think about the problems that exist in the criminal process, then we are overlooking a critical piece of it. In fact, we would be overlooking a piece that's so critical that it's enshrined in our understanding of the Sixth Amendment right to the effective assistance of counsel. It is the public defender who we can consider to be a primary symbol of fairness in our criminal process. And as my research conveys, we should be looking at the public defender more closely to determine if it is operating in a way that is most likely to maintain fairness. I mean, a defendant, no matter if they are guilty or innocent, is entitled to have a lawyer represent them if they are facing incarceration. And if they are unable to afford one for themselves, they are entitled to have the state provide one for them. Our system of mass incarceration, a nation of high poverty levels, means that it's this entity, the public defender, who represents by some estimates 82% of defendants in criminal courts, that should play a central role in any conversation we might have about whether the criminal process is working the way that we want it to work. It's the public defender who is tasked with elements of and actually has the capability to address so many of the issues that occupy these reform conversations right now, whether it's ending mass incarceration, combating racial injustice, addressing economic inequality, or lending a higher degree of procedural legitimacy to immigration enforcement. So the public defender needs to be central to our conception of the problems, and yet we haven't quite yet figured out the best way for it to operate. With all of these issues that have been occupying our national conversation over the last few years, and will likely continue to do so for years to come, exploring if there are better ways for the public defender to function is necessary for anybody or any institution pursuing change to actually achieving it. My presentation today, Learning from Mistakes, Lessons in Legal Ethics and Criminal Procedure, examines a significant point of inquiry and discussion that, to my mind, has been overlooked in our conversations about who the public defender is, what the public defender does, and how the public defender should do its job within our system of legal ethics. And that's how should the public defender respond to mistakes or failures that it has played a part in. On October 3rd of 1997, Damon Thibodeau was convicted and sentenced to death for a crime he did not commit in Louisiana. His wrongful conviction bore many of the same hallmarks that scholars have come to recognize often accompany such gross miscarriages of justice. It included a false confession obtained after hours of police interrogation. It included claims of prosecutorial misconduct. Right. After spending 15 years on death row, Mr. Thibodeau was finally released. DNA evidence confirmed he wasn't the person responsible for raping and murdering Crystal Champagne, his step cousin, who had been found dead after leaving her family's apartment in July of 1996. When a defendant is exonerated and released from prison, whether or not it's from death row, calls for systemic improvements meant to prevent such miscarriages of justice from happening ever again usually follow in the period right after. And sometimes these calls are heated. Some police departments have, considered and implemented changes to their interrogation procedures to prevent false confessions. Some prosecutor offices have established conviction integrity units tasked with reviewing previous convictions to ensure they are just. Several states have completely revamped their delivery of public defender services in response to lawsuits brought forth by wrongfully convicted defendants. These changes, however, are not routine. They do not occur in all police, prosecutor, or public defender offices, and they seem to arise as a result of circumstances unique to that case and unique to that jurisdiction in which the actual offices reside, instead of a more systemic approach to addressing flaws in the larger criminal process. In the medical field, mortality and morbidity reviews are routinely used to help practitioners improve their patient care. These reviews involve careful evaluation of the steps and behaviors of individuals with decision-making authority, often by the institutional body that's tasked with licensing these decision makers to act. They provide an important mechanism for practitioners to learn from their mistakes and improve their practice while participating in a formalized professional method of reviewing them. It's a way to ensure these mistakes don't repeat themselves. State criminal practice doesn't have the same formal, systematic, and dedicated evaluations of appellate reversals. Indeed, those offices that were involved in Mr. Thibodeau's wrongful conviction have yet to engage in any public inquiry similar to those in the medical field, despite the reality of criminal proceedings also affecting life in the same way. This inaction is actually not uncommon in Louisiana, right, or any other state facing, similar examples of failure. The police, the prosecutor, the public defender institutions involved in Mr. Thibodeau's case, and those like it may not view their involvement as necessarily problematic, right? They could argue that although Mr. Thibodeau may have raised claims of ineffective assistance of counsel and official misconduct on his appeal, those claims were unsuccessful, and his exoneration was instead based on actual innocence. In other words, the system actors might believe the appellate claims about trial conduct were ultimately groundless, and so there was no compelling reason to make changes to their practice of law, right, or policing, right? But how can one assume those claims are groundless when they were made and Mr. Thibodeau was actually indeed innocent, right? This argument inspires a larger question about the public defender's role in the criminal justice system by asking, what should an individual public defender and the public defender institution that facilitates their work and the legal institution in charge of licensing the attorneys that work in both do after a reversal like that? The reality is that there are three bolts of lightning that should strike at any public defender or public defender institution and force it to reassess what it is doing. The first is when an appellate court holds that the public defender has failed to provide the effective assistance of counsel and thus violated the Sixth Amendment to the US Constitution. The second is when one of the public defender's clients who have been convicted is found to actually be innocent, either through the introduction of scientific evidence or something else along those lines. The third situation that should cause a public defender to sit up and take notice may not be as obvious as those first two, but it's when the prosecutor or a prosecutor's office the public defender interacts with in the criminal process is found to have committed some sort of prosecutorial misconduct. In the first type of case, the Sixth Amendment violation, any reasonable public servant would ask, oh, what did we do wrong? And what can we do to make sure we don't make the same mistake again? In the latter two types of cases, actual innocence and prosecutorial misconduct, the question would be, could we have done something to prevent or catch this? And again, what can we learn from this situation to stop this from happening again? I'll explain each of these three types of mistakes as I categorize them a little more fully in just a moment, but I want to first describe how I developed this course of study the course of study I used to answer these questions. My first step was to determine the universe of cases I'll review for information about what's currently going on and whether we would describe it as adequate and comporting with our ideas about ethical and professional legal representation. I chose to limit my data to defendants sentenced to death who were later removed from death row. So that is people who were charged with homicide and facing what many would consider the harshest penalty in our legal process, execution by the state, determined to be indigent, represented by their jurisdiction's process of providing representation to indigent persons, convicted and then sentenced to death row, and then eventually removed from death row because of an error found in their conviction. Some might say that of those cases, the ones that should be most concerning to those of us evaluating the system for improvement are those where the individual was fully exonerated or found innocent of the crime through DNA or other scientifically verified evidence. I don't think that narrow definition makes sense for this course of study, since I'm trying to look at whether the system performs with integrity. And part of performing with integrity involves defendants who may not be proven factually innocent, but were still denied a proper constitutional or professional legal process. So for this study, I decided to take a closer look at all death row reversals since the death penalty was reinstituted in 1976. The subjects I used for the study may have been removed from death row for a number of reasons, but the primary ones I explored were ineffective assistance of counsel, prosecutorial or official misconduct, and actual innocence. And for this universe of cases, I set about to explore what happened to the defense attorneys who were involved in each individual case that was eventually reversed. Did they receive some additional training or supervision? Were they disciplined by the state bar or their employer? Were they sued by the private individual? What consequences did they face or course correction were they subject to because of this mistaken conviction? My next step in developing the project was to fully define mistake as I saw it. And I chose to pick those three scenarios that I described for you earlier that tend to dominate appellate reversals. The first is the classic ineffective assistance of counsel, right? That's the Strickland versus Washington standard, where appellate court finds that the defendant's attorney provided a deficient performance and that the deficient performance prejudiced the outcome. That's a very difficult standard to meet because you have to meet both prongs. In fact, David Washington, who was the subject of the Strickland versus Washington case, was actually executed 2 months after the decision because the court didn't find that his appellate claims met that burden. But sometimes you'll see situations where there is a deficient performance, but the defendant is not entitled to relief because they're unable to show prejudice, right? And in light of that, it seems that there should be some professional duty by the public defender to review and reflect on the cases that are not reversed because only the first prong of deficient performance is deemed to have been met, right? I'm still working through how our system of legal ethics and professionalism would speak to that kind of failure. But in the meanwhile, for this study, I looked at those cases where both prongs were met, right? I think it's easier to include those cases in this study just because, even the most casual observer, I imagine, can understand how the reversal of a case on the full achievement of the ineffective assistance of counsel claim is deserving of some sort of review and reflection. For my study thus far, to the extent they do try to learn from their mistakes in these type of events, the process would seem inadequate, particularly if you compare it to the systems in place for other entities or professionals to learn from their mistakes in situations where they're involved in life and death decisions. Whether it's the medical field, as I said, with its mortality and morbidity conferences, if it's aviation and the full investigation that follows every flight accident, whether death is involved or not, or if it's nuclear power with the stringent regulations that exist to prevent such devastating effects as we have unfortunately seen in the past. We see in these other areas a full accounting and a review of every step in the process where a similar error might occur in the future so that it can be adequately addressed. For some reason, the public defender institution and the state bars that are tasked with licensing them don't engage in the same sort of sentinel review as those other entities. Instead, it seems that there's really two primary ways that these types of mistakes are currently addressed. And I think both are inadequate. The first is employment related, and the second is litigation related. There's not a formal, nationally accepted and rigorous process for an attorney who was primarily responsible for a reversed case to receive some sort of training or notification to prevent their deficient performance from happening again, or the similar action to occur from an attorney that otherwise works in their office. It's true that often death row reversals happen decades after a case has been disposed of, right, through the legal process. So part of that might be because the chance of correcting the attorney's specific performance is unlikely. But as I said, that training on that attorney's failure in the particular case could impact the decisions other attorneys might make in their own similar cases. And the same can be said about the office or institution that serves as an umbrella for that attorney and their deficient unconstitutional performance. There's no formal process in place to shift the way an institution supervises, trains, or oversees cases that bear similarities to ones that were overturned. Even our state bar associations don't necessarily have a universal formal process in these types of situations for getting involved in their own accord and reviewing the attorney to determine if it's appropriate for that attorney to remain a member of the bar in good standing. The attorneys don't automatically face disciplinary charges or to even go along with the institutional mind I'm trying to bring to bear in the discussion of professional rules and the legal profession. State bar rules don't demand change from the office or agency itself, perhaps with regards to its hiring decisions or its training processes for the role it played in facilitating the miscarriage of justice, the wrongful conviction. The second type of mistake I looked at is official misconduct, and what many of you might popularly think of as prosecutorial misconduct, a Brady versus Maryland violation, the failure to disclose material and favorable evidence to the defense. This requires showing a reasonable probability that the trial outcome would have been different if the evidence had been disclosed, right? Or really something that undermines confidence in the outcome. So you'll notice again the sort of twin prongs that have to be shown in order to achieve appellate relief, right? The evidence must be of a sufficient nature of materiality, and it must influence our sense of the appropriateness of the outcome. So this is another situation where it seems like a reversal should trigger some sort of reflection. But even if it's just the first prong or one prong, that's implicated. Now, it may seem unusual or shaky to classify official misconduct as a mistake the public defender should be learning from, because it's the failure of the adversary, right? The government to comply with its own constitutional obligations. I include this as a mistake for the public defender to reflect upon because the criminal justice process is a process of repeat players and repeat institutions. It brings to mind the popular saying, fool me once, shame on you, but fool me twice, shame on me, right? It's getting at the idea that we should all learn from the first time we are tricked or someone fails or harms us and take subsequent steps to protect ourselves from falling victim to the same circumstances again. Now, there might not be anything public defenders can do to force the associated prosecutors to change their practice, right? But being on alert may help improve their defense or might lead to a larger campaign addressing government misbehavior that could help future clients. The basic reason I include this as a mistake for the public defender to learn from is that we can't know what steps we might need to take to account for the possible misbehavior or failure of others without some type of formal review or process of the situations where they have misbehaved or failed in the past. When we think about other sorts of sentinel reviews, particularly aviation, we see how there are often duties imposed on one set of actors to account or look over the work of other actors to prevent a possible repeat failure. I haven't been able to find any formal ways public defenders have addressed these type of failures by other systemic actors like the prosecutor, but I do know anecdotally, this can sometimes just be in the form of motions filed before a court, asking for the court to order the government to do something specific or refrain from doing something specific in advance of it occurring. I can describe some of those in our follow-up discussion if you like. The third type of mistake I identify is similarly not attributed so easily to the public defender's actions, and that's actual innocence, right? So as I mentioned in opening this talk, Damon Thibodeau was wrongfully convicted and sentenced to death for a crime he did not commit. After spending 15 years on death row, Mr. Thibodeau was finally released after DNA evidence confirmed he wasn't the person responsible. Mr. Thibodeau unfortunately died in September of 2021 from COVID-19, less than 10 years after his release from prison. And, I pray he rests in peace. And among the many things I hope we're able to do in his memory, one is to consider what the public defender institution could have done differently. I mean, there was an innocence story for Damon Thibodeau that wasn't told successfully by the attorneys representing him at trial. And it would seem that we could use his unfortunate experience to learn how one might better tell that innocence story. Of course, that idea, it begs a larger discussion about whether we can or should equate, not telling a defendant's story successfully as comparable to not telling a defendant's story effectively, right? Since effectiveness is the specific language in the Sixth Amendment. What we know is that the actual reality of Damon Thibodeau was he wasn't guilty. And so maybe we can learn from his situation how attorneys similarly situated could articulate a more effective and competent successful story in their defense. I include this as a review more so in thinking that the public defender can explore if there are certain paths to investigation or narratives they could adopt for future cases that would help clients who may not end up having access to the same sort of DNA evidence that was fortunately available for Damon Thibodeau. My central goal in identifying these three different types of mistakes is to explore how public defenders learn from them, right? And what legal ethics would require them to do in order to prevent these kinds of injustice from happening again. This is how the actual innocence story could fit in. There should be opportunities for individuals to reflect on their particular performance and the institutions that house them to consider formal steps they can institute as a backstop. So the two methods that I've seen for addressing these type of mistakes so far that I consider inadequate are employment and litigation. For employment, you have the traditional supervisor-supervisee relationship and performance reviews. This could include assessments of whether the individual attorneys should be advanced or removed from more serious cases, right? Serious cases. Those of you who are familiar with my past work will understand why I put that in quotes, since I advance the idea of misdemeanor offenses as being critical and deserving representation by the most experienced attorneys. But what the bottom line is that I think, that these kinds of individual employment responses to these kinds of mistakes aren't sufficient, right? You can imagine why. The supervisors are often themselves overloaded with work, and such a review can seem a bit too personal and intimate to fully satisfy the kind of objective evaluation that would encourage large-scale formulate change on attorney behavior and practice. There could also be systemic reviews in that some public defense institutions do need to provide some sort of accounting or report to their funding authority. However, those are primarily about funding and not so much about the reversals that might occur in the cases and defendants they represented. Another form of learning from mistakes are individual state bar misconduct hearings. I find these to be insufficient as well, both in terms of them, requiring some sort of formal complaint, right? And also because the proceedings are private, so there's no full public understanding of the evaluation process. A second way of learning from mistakes is through litigation, and that's both criminal and civil litigation. There are two primary ways. One can sue their attorney for representation errors. A client can file a suit alleging the attorney committed malpractice, and alternatively, a client can bring a civil rights action against their attorney. Traditionally, public defenders have been compared to private attorneys, and courts have held they can be subject to malpractice suits, but those are certainly proven insufficient. State courts are kind of split on the issue of immunity of public defenders from state malpractice suits, and civil damages are extremely rare, right? Citizens of any jurisdiction, public defenders are beholden to the same criminal statutes their clients are charged with violating, but connecting criminal violations to their legal practice is even more difficult. In fact, professional responsibility classes throughout the nation spend time discussing one such attempt at holding public defenders criminally responsible, providing a high degree of competent and loyal representation. That's the buried bodies case, which I'd be happy to talk more about in question and answer. There's also, the court also has the power to hold a defense attorney in contempt, right? It could be a civil or criminal sanction. Contempt of court is, by my mind, an inefficient way for public defenders to learn from mistakes. First, the offense is only properly applied where the attorney has violated a specific court order or disrupted the judicial proceedings in some way. Many of the mistakes that contribute to wrongful convictions arise in the investigative process of representation. Accordingly, these aren't actions or behaviors that would necessarily appear before or even be apparent to a court. Additionally, the offense itself does not explicitly encourage the defense attorney to consider the mistakes they have made in connection to the defendants that they are representing before the court. A criminal contempt charge is more properly considered an opportunity to reflect on the ways the defense attorney has disrespected the orderly management of the court process, instead of the ways in which they could have learned from the mistakes they made during the course of representation for an individual client. So, after finding, the current more popular methods of addressing failure inadequate, I suggest a more formalized method for the public defender to learn from its mistakes. By my mind, this method could better improve the individual attorney's practice of law and the institution's internal and external decision-making by drawing on different behaviors by the individual, the institution that houses the individual, and the state licensing mechanism for legal practice. The first method I would suggest would be to rethink the trial and appellate relationship. There's an understandable need to some extent for there to exist some separation from the trial attorney and the appellate attorney for a case. Often the appellate attorney provides a fresh set of eyes and a different degree of expertise that inures to the benefit of the client. Additionally, the separation may facilitate any claims of ineffectiveness of counsel the appellate attorney wants to make involving the trial attorney's work. It might make it seem less personal, right? Trial psychosis is a very real thing where the trial attorney really believes strongly what they did for a trial. That's certainly been my position in every trial that I've done. But I should note that my experience has actually been that trial attorneys are willing to engage and support appellate attorneys who feel like the trial attorney may have done something ineffective. The majority of trial attorneys I've worked with, myself as well, have been fully willing to acknowledge that they wish they could have done some things differently or some things better. And sometimes even some states require trial attorneys to sign off on the appellate record or the trial transcript. But what I'm hoping for here, what I'm looking for here is something beyond that sort of formulaic engagement, some sort of deeper involvement in the appellate process that would allow the trial attorney to reflect more fully on what they did at trial. That actually comes from an anecdotal sort of experience I had myself in practice. It's an original thought, from my own experience. When I was in trial practice, we had an interlocutory appeal system in Louisiana. So I knew about some of the appellate issues I raised during the trial phase that were heard by an appellate court, in advance, right? And as the introduction noted ahead of time, I'd first started after law school doing appellate work in Alabama with the Equal Justice Initiative. And I remember in that post-conviction work, I'd read trial transcripts and say to myself, what kind of, bad attorney would ask this question or not make this objection? And then I became a trial attorney and I saw how you could become that bad attorney that didn't make, this objection or didn't ask this question, right? And so that's where this idea of having the trial attorney be much more involved with the appellate attorney work comes from. Having done that work myself as an appellate attorney first, and then becoming a trial attorney, I saw how valuable that was to my growth as an attorney. I'd also be happy to talk more about that in question and answer. The second thing that might need to shift is a better system for assessing how the different competing adversarial agencies relate to each other, right? An important takeaway from any reflection of mistakes concerns how one might interact with other individuals who make decisions in the same space. The criminal court adversarial process is a delicate interaction between two opposing forces who nonetheless must operate under the same rules geared towards maintaining the system's integrity, right? Whenever two parties routinely oppose each other, it's important for both parties to reflect on how the opposing party has acted in similar situations and shift their own style of practice to account for any misbehavior, possible or not, by the other party. And this can range from simply being on alert for any potential future violations to refusing to engage in certain exercises with the opponent, given their history. I should note here maybe that my work's move towards thinking about sentinel reviews for public defenders would be more like advancing something beyond the basic effective assistance of counsel that Supreme Court jurisprudence has read into the Sixth Amendment. That's one way of seeing it. But I think the better way of viewing it is as an important step to building a system with integrity, which is the fundamental goal of the profession and certainly of bar licensing entities, right? And so that's why my third and final suggestion to encourage reflection is more formal, routine, and perhaps mandatory responses from state bars and licensing authorities when a conviction is overturned. Right now, for the most part, it's up to individuals to file complaints with the state bar. But imagine if an appellate reversal automatically triggered some sort of review. Not automatically triggering license suspension or revocation, but just a review to ensure rules are being followed as closely as they could, or to even consider whether new rules should be adopted and put forth, right? This isn't to mean that a public defender who happens to be assigned a client who is convicted and then has their conviction overturned should be automatically disbarred or suspended or reprimanded. That shouldn't be the case, even if the reversal is based on ineffectiveness of counsel and our state bar mandates competent representation. It should just be a trigger for the relevant state bar to take notice and assess if there is something else that needs to be tested or some other standard that needs to be required to prevent such a mistake from happening again. In closing my remarks, I think it's important for us to recognize that public defense institution can occupy space in different lanes at the same time. So it can exist in a lane that's focused on racial equity and providing support and care for the most marginalized members of society. But at the same time, without adequate reflection and introspection, it can also exist in a lane of contributing to the behaviors that exacerbate racial and class-based violence and trauma. So public defenders can't just exist to point out the mistakes or failures of others and then be defensive when it comes to considering their own and unwilling to learn from their own. Although this article, this work, everything that I do, this talk centers on public defenders and limits its data review to reversals of capital convictions, its implications are relevant for a wide variety of cases and legal actors within the criminal justice system. While cases involving a capital offense may require a more involved court process for determining penalty, and individual states may require a higher level of experience or training for attorneys in the death row representation process, it's true that all attorneys in criminal practice are tasked with meeting a set standard of professionalism and competence by state licensing mechanisms. All prosecutors are tasked with performing as ministers of justice in all criminal matters, and all defense attorneys must provide competent and effective assistance of counsel when representing any defendant at a critical stage of the proceedings. Conviction integrity units have become more common in prosecutor offices throughout the nation in response to calls for criminal justice reform and recognition of the failures that might occur in prosecuting those accused of criminal behavior. There's been no similar widespread creation of units dedicated to reviewing public defender actions in the indigent defense arena. And it's important for us to consider what a walk down that path would look like as part of a general and more expansive move forward in this moment of racial reckoning and consideration of the problems with the criminal process. Thank you all so much for listening to this talk. Thank you again to PACE for inviting me to give this memorial lecture in honor of Philip Blank, and to all of you for engaging in this project with me. I look forward to your questions, suggestions, and overall insight. As I mentioned earlier, my hope is that this project really gives us something new to engage and think about when it comes to how we theorize the public defender institution, but also gives us, specific tangibles to take and implement going forward in the important work that the public defenders do. Thank you.
Thank you so much, Professor Joe, for your comments and for all of your incredibly important work on this topic. So my role here is to be the interpreter of questions and share with you the questions that we've gotten so far from the audience. So the first one is about lack of funding, right? So is lack of funding for public defender offices, their overwhelming caseloads, really the kind of core problem here, along with the general lack of prestige that public defender positions often have. And the questioner here pointed to the example of the difficulty that the recent Supreme Court nominee received for her work as a public defender as part of her confirmation process.
Thank you for that great question. My hope is that nothing I say or any work I publish or study that I do would minimize the very real significance that adequate funding and adequate support the public defenders need in order to do their job. That's certainly a really important piece. What I try to do with my work is to recognize that even within those limitations, right, there are things that the public defender can do to try to improve their practice of law and the representation of clients. At the same time as we're requesting more money, we're requesting more prestige, we also have to recognize the individual, behaviors that public defenders and the institutions that house them engage in that are a problem that have to be addressed, going forward. The prestige is always, it's always very frustrating. I listened to the hearing with everybody else with the, sort of excitement for her having had experience as a public defender and what that might mean in terms of Supreme Court jurisprudence going forward and how they might interpret, different cases that arise before them. I shouldn't, one of the things that I appreciate most about being a public defender, I think it comes from my background as an immigrant. I was born in Nigeria. I came to the States when I was very young, and then I got my citizenship in college. And when I think about some of the studying for the citizenship exam, speaking with my parents about how great life in Nigeria was for them, but also some of the things they looked forward to in the US, the idea of the public defender was one of those ideas that just really set forth what they were looking for in creating a life here, right? This idea that even if you are a person that is, completely guilty of the worst act ever, and the government is trying to pursue a path to punishing you, we care so much about the individual and their rights and the protection of them that the government has to fund somebody to defend you against them, right? I think there's something beautiful about that. I think there's something really extraordinary about that. I'm not quite sure why that story wasn't able to take as much hold in the hearing for hopefully future Justice Grant Jackson, but hopefully with her, if she's able to obtain a position on the bench, it's able to be told much more loudly.
I hope so. So another question, and this one is from a recent PACE Law alum who shared a little bit about his own experience with wrongful conviction in the chat. And he asks about the sort of failure of the ineffective assistance of counsel framework that you talked about a little bit. So he points out that in New York, there is a totality of the circumstances test. So a lawyer who doesn't call a really critical witness, but gives a fine closing statement won't be ineffective because the court will kind of look at the whole picture of the representation. So how much do you think a kind of overhaul of that legal framework is also an essential part of the story here? Oh, you're...
Of course. Of course. No, I think there's work to be done with the infection. In addition to some of the things I talk about how the attorneys themselves should engage in reflection of that, but the standard itself could certainly use some work. There's a hesitancy, which I don't quite understand, not to engage in backseat driving or Monday morning quarterbacking of criminal defense. Right, for those of you who are not sports fans, Monday morning quarterbacking, the football games on Sunday, usually the Cowboys lose, and then on Monday I'm complaining about what the Cowboys did, right? But the idea is that we don't want to engage in that. And I'm of the mindset, why not? For something that important, something that involves that degree of influence on people's life outcomes, we should be doing everything we can to engage in the Monday morning quarterbacking, backseat driving, right? And so the ineffectiveness of counsel standard as it reads right now, right, is about not doing that sort of questioning or of what someone's strategy might have been at the time. But we certainly are willing to do that when it comes to medical problems, right? We thankfully are willing to do that when it comes to aviation decisions that lead to the loss of life. Same with nuclear power. In military, with military, they also engage in the same sort of reflection about military exercises and things like that. And so I'm not quite sure why we're so against doing the same thing in the criminal context. I want to thank you so much for your question and hope to at some point interact with you one-on-one so I could learn more about your experience and how you might see the sort of ways the attorneys that were involved in your case might have learned from what happened.
So a follow-up question on that. The anecdote that you started with is sort of comparison to the medical profession I found very striking. And I have some kind of instinctual, cynical answers to this question, but I'm curious to hear sort of what are your thoughts about why the legal profession handles this kind of thing so differently? So, I'm going to add on one of the audience questions to this as well. An audience member points out that his large public defender office has sort of lots of mechanisms for, being excited when something goes well, but doesn't have a kind of formal office procedure for when there's been a loss, right? There's sort of silence in the office around losses. So do you have any kind of instinct on why the legal profession handles this so differently? Because I don't know a lot about the medical profession regulation, but it's also self-regulated in sort of similar ways to the legal profession. So why are they so different and how might we improve that?
Yeah, that's another course of study. For the first point about the legal profession compared to the medical profession, it might be as simple as everybody recognizes or believes at some point they could be subject to having to need help of a medical professional and is not quite as willing to see themselves or family members like that's not their problem. That could be it. It could also be some degree of people thinking that anybody that's somehow entangled in the criminal process has sort of deserves it, right? Or forfeits their right to be cared for as individuals in this joint enterprise of life and society that we see. I'm not sure. I do think, as you sort of point out, that if we get down to the fundamentals, there really is no difference, right? And to some degree, our responsibility is sort of more striking in the legal profession. We think about what's included in the Constitution and how clearly it sets forth these duties and these requirements and the standards that we're looking for in the criminal process. It would suggest that we should be even more detailed to that degree. To the second point, to the person who talked about how their large public defender office has, that is very true. That was also my experience as a public defender in New Orleans. And I think there's some need for that. It's already disheartening, I think, when you lose, right? To think about, you know, one of my a good friend of mine, I lost a really bad homicide trial, and I just remember her driving me to the beach in Florida that night, just so I could just relax and think and not feel so guilty about what I could have done beforehand. But to the extent that we're willing to do that, we're just, you know, I think we're not allowing, or we're not enabling public defenders to do their job going forward. All we're doing is just like increasing the likelihood or the possibility that something similar could happen again in the future. It's a hard responsibility to confront your failures. I think we all recognize that as human beings, no matter what industry we're in, but it's also a really important one because we all recognize that's the only way to grow and truly move forward.
Absolutely. So here's a question from my colleague, Professor Dorfman, about the study design. So in focusing just on death penalty cases, does that limit your inquiry to states with an active death penalty, which are often states that have, you know, particularly under-resourced and financed public defense systems? And maybe as a sort of next phase of the study, do you have a sort of interest in looking beyond the death penalty context here?
So the truth be told is that this project really developed because I wanted to say something about misdemeanor representation, the lack of appellate work in misdemeanor cases, and how that needed to be done more. The reason I limited to death penalty cases was to limit the amount of data I would have to review for this first project, but certainly future projects are going to be looking at both felonies and then misdemeanors. Those projects, as they're designed, it's going to be looking at specific jurisdictions, I think is the way that I'm going to do that, to sort of limit the number of cases. But no, I'm glad to hear your interest in that kind of a project going forward, because I certainly am looking forward to doing it. Yeah, and there's also, it's not even just about the public defender. Right now, you know, this is my area of interest, my expertise, what I, you know, hope to be speaking to. But it certainly is going to be a conversation where we think about what prosecutors should be doing differently, right? You know, one of my previous projects looked at is the prosecutor's ethical obligation to assist public defenders who are unable to manage their caseloads. And what does that look like, you know? And then the same thing with judges. To what role should judges play? I'm teaching a seminar right now, comparative criminal justice, where we're looking at how, you know, the criminal process operates in other countries in the US, and sort of thinking through, you know, how do people become attorneys there? How do they deal with their past histories of marginalization and the influence it might have on their decisions, you know, that are set forth right now, and things like that. And it's been fascinating to look at how other countries do it. And I think that that's something that we could also learn from. We had some guest lecturers from Canada, Nigeria, and South Africa most recently, and to talk about judges and the role that judges will play in their systems. And the students and I, we were really talking through how, to some degree, our description of judges as being neutral might not make sense given the obligations that we set forth on the public defender, right? And the obligations that we set forth on the prosecutor. And so maybe defining judges a different way might be part of our process going forward. So a lot of questions to be had, a lot of studies I'm currently engaged in, hoping to engage in the future, but hopefully some will provide some answers that will certainly help.
A full life's work there for sure. So a question on a different topic from another audience member is interested in hearing more about cooperation between trial attorneys and appellate attorneys, and in particular about kind of current ABA guidelines for what that relationship needs to be, and sort of how you envision expanding those obligations. And if I could tack on my own kind of additional question to that, I was wondering, as you were talking about it, I've heard you speak a lot before about the ways in which a lot of public defenders are really overburdened and are kind of doing this triage in their work already, just to try to be able to serve the needs of all of their clients. And so I was curious and kind of thinking about, what does it look like to have them get more involved in the appellate process too, when they're already so stretched thin?
I know that's a concern. That's something I have to work through. I actually just published a piece in the SMU Law Symposium. I was fortunate enough to write it with two students who, one is now about to become a public defender, the other one's about to do a fellowship and become a public defender. We talked about how in this moment of racial reckoning, we've seen some advancements, particularly in California, in terms of sentencing and things like that, but no one's considering, even if the law changes to try to advantage defendants and those who have been incarcerated on, but no one's thinking about what the attorneys will have to do, right? And who's going to do that work. And one of our solutions was to look more towards the appellate bar to help that whole process. And so that was a really great project to engage in. The trial attorney and appellate attorney interaction, it might start off with it might be as simple as just one specific portion of the case that they're looking at, right? Or maybe it could even be sort of a randomized check. Sort of when you think of, at the airport, there's certain things that are automatic, but then sometimes there's a random check just to make sure everything is going smoothly. And that might be a way to reduce the amount of work. I just feel very passionately about that. As I said, with my in Louisiana, we had an interlocutory appeal system. I'll always remember, I'd represented somebody on a charge and done a motion to suppress, and I'd lost. And so I was appealing that loss, and I got the trial transcript and I read it. And I just remember as I read it, it said the attorney, me, had asked the police officer about the nautical clothing that he claimed the defendant was wearing. And I know when I looked at that, I must have been, I don't think I've ever used that word in my life. Nautical? What is nautical? And then after a lot of thought and discussing with other people, I realized what I'd said was an article of clothing. And to this day, because I read that and realized that I have a tendency to run those words together in casual conversations, you'll notice that I take a pause between an article. And so that's the kind of learning that I would hope might come from just engaging with an appellate attorney, engaging with your own transcripts, and to prevent such, natural tendencies from happening in the future. And every little bit, I think, would help. It would certainly be more than I think what's happening right now. But as you say, the workload is something we have to consider and think about.
Great. So I'm just looking back at the chat. There are a few more questions coming in. So another question about ineffective assistance of counsel, and I know this isn't the sort of primary focus of this work in particular, but the question is about whether you're aware of any patterns in ineffective assistance of counsel, and in particular whether there are patterns by age or by type of organization that public defenders are working for, and is it you could imagine this sort of going both ways, right? Younger attorneys making more mistakes because they're more inexperienced, or older attorneys making more mistakes as they are kind of less, more complacent, less eager to really dive into the work.
Yeah, that's something to consider. I'll say, so one of the projects or the studies that I'm trying to design right now, I'm trying to team up with a PhD to do this, a psychology PhD, is, what should go into public defender hiring decisions, right? Like what kinds of attorneys do you want to, emphasize or prioritize for which type of offices? Because I think that might play a role. Some of you may have heard me speak before. I've talked about, the 3 different public defender motivations that Jeff Shear and some others have put together, where, talks about how there's basically 3 types of desires to be a public defender. There's the And they go with three different quotes. And the first is by Friedrich Nietzsche: distrust all in whom the will to punish is powerful. And that's the warrior who wants to, fight against the government, because anytime the government is tasked, takes on the role of valuing human life, you could see the problems with that. So there's the warrior. And there's also the social worker, and that's the Sister Helen Prejean quote of, each person is worth more than the worst thing they've ever done, right? And then there's the third, which is the movement builder, which the quote that's sort of tied to that is, never doubt that a small group of committed people can change the world. Indeed, that's the only thing that ever has. And that's popularly attributed to Margaret Mead. And so for this study that I'm looking at, there's an idea that I would like to get a sense of what type of office setup works best for which type of motivation, right? Because you can imagine somebody like me, who, I'll be very honest, I more closely attribute to the movement builder sort of model, fit very well in an office in New Orleans, right? Which was starting from scratch post Hurricane Katrina and trying to build something that would be a model going forward, right? But, the supervising leadership structure within, sort of had me then turn to academia as a way to deal with some of the things that I saw that were a problem for defendants, right? We can imagine a different type of office might be better suited for a warrior or a social worker type model. And so it wouldn't surprise me if the likelihood or the sort of the errors we see for different attorneys might track the different motivations, and which would then suggest that different offices need to have certain sort of checkpoints in place, as those are more likely to happen given the type of attorney somebody is or type of thing that motivates them.
It's really interesting. So one more question, and this is again from our alumnus who is himself wrongfully convicted. He throws out the idea of reorganizing public defenders' offices so that they operate on a statewide basis. And just to clarify, my understanding is that they're typically much more localized and jurisdictional in a lot of places. So the motivation to do that would be to have more uniformity and more potential for oversight, and at the extreme to prevent a public defender who has been sort of doing badly in one place from just kind of relocating somewhere else in the jurisdiction and picking up a practice there. What do you think?
No, that's a great comment. It actually fits along. So one of my other areas of interest when it comes to public defender, and it's a piece that I published just 2 years ago now, the pandemic, maybe it was last year, I don't know, Structuring the Public Defender, where we tried to look at how different states organize their provision of services to indigent defendants, right? And some states do it because even with the Gideon decision, sort of setting this forth, the court did not tell individual states how to do it. So every state sort of picked its own model. And some states organize it and the funding and the supervision at the statewide level. Some do it at the county level. And even within the statewide level, some will do it through the executive branch or the judicial branch. There was even a state that had a few legislative members on their board to help organize or think through the regulating of the public defender. And as you know, there were some benefits when I did that study to having it organized at the state level as opposed to the county level, funded and regulated at the state level as opposed to the county level. Indeed, that was the change that was made post Hurricane Katrina in New Orleans. At the time of Hurricane Katrina, it was organized at the county level. Each individual county was responsible for figuring out its management of services. And then Katrina made it very clear that that was an awful process for Louisiana. And so then abolished all those local county boards and created one statewide board, which I eventually worked with as an assistant training director. So yeah, there were some positives to that. The sort of the regulation, the uniformity, things like that were great. But one of the things that I noticed was a problem is that one of the benefits of the county level representation is that it was much more responsive to the needs of that individual county, right? You can imagine that there are certain needs and experiences that the citizens of, I'll use where I live now as an example, Sacramento or Davis might have different than San Francisco or Los Angeles, right? And so that you want to be able to focus on providing to those situations and scenarios in a way that it might be difficult to do so if you are worried at the state level. So that's sort of I do think for the most part, at least when it comes to the structuring process, it seems like doing it at the state level makes more sense, but that you still need some sort of representative, right? To ensure that individual counties, that this process will sort of will speak to their unique experience and setup. And that would be, I think, the addition that would help.
That makes sense. So we're have time for one last question, and I think this is a fitting final question, which is, in addition to your bio and your other work, which I already put a link to in the chat, are there other articles and resources that you would recommend for members of the audience who want to learn more about these issues?
Oh, absolutely. So I would say, so my friend Sean Owusu at the University of Penn has done some really phenomenal work on public defenders and legal ethics. He talks a lot to some of his work, to really think through the racial dynamic of the public defender, right? I think Devin Carbato has some really great work and ideas about how so much of the criminal process is sort of built on the backs and the pain and the frustrations of Black and brown bodies, right? And we need to recognize that and address that. And so then it also makes me think, one of the other things I like about Sean's work is that, so maybe the legal profession in terms of its institution of rules and things like that should also, recognize that in advancing certain guidelines and things like that. To the extent that the profession itself confronts its own history and the ways in which, to some degree, it was developed as a way to keep certain groups out of legal practice, and thinks about how it might be fostering or continuing that in both its rules now and the rules it fails to adopt now. I think it would be a really important thing to consider. So Sean's work would be great. Tinu Adederan, who is now at Fordham, I believe, is also great too. She does a lot more corporate sort of things, but her work about the legal profession and the racial dynamics with it is just astounding.
Wonderful. Thank you. So I was a little too slow on the last one, but I put links to the bios of the first two people that you mentioned into the chat. We are unfortunately out of time, but thank you so much for spending this hour with us. I learned so much. As always, it was such a pleasure to hear you speak. So thank you so much. And thanks to everyone for joining us today.
Thank you so much. It was truly an honor. Thank you.